Okay, the last part of our Kentucky Realtors Statewide Contract video vignette series is going to deal with the notices and with the mediation and arbitration provision, and then finally just with the signatures. So let's start first with the notices. As you'll notice, that begins on line 229. Again, we're running along the left-hand side of the contract. And the first part, paragraph 19, deals primarily with the smoke detector ordinance. Now, for right now, it's my understanding that that is only required in Jefferson County. There was a question about whether to include this in the statewide contract, but since so much of the membership is in Jefferson County area, it was decided to go ahead and include that. Now, the next section, you have the condominium seller certificate section. And it states that if the subject property is a condominium and a condominium seller certificate has not been previously provided by the seller, seller agrees to immediately request a condominium seller certificate at seller's expense and provide it to buyer pursuant to KRS 381.9203. Any additional condominium association documentation, including updates requested by buyer's lenders, shall be paid by the buyer. It's important that you talk to your clients about this in advance, so that they know that there may be charges coming to them, especially on the buyer side. There may be charges coming to them if they, in fact, make an offer on this property. Now, the next part I want to talk about is line 239. That's paragraph 21, and that deals with the risk of loss. Now, a lot of people don't know this, but unless you have a risk of loss provision in your purchase contract that says that any risk of loss shall remain with the seller. If you don't have that language, then for example, if a buyer were to buy a property and with a house on it, or make an offer and get an accepted offer on a property with a house on it, and that house were to burn down, let's imagine the seller didn't have insurance, arguably the buyer would have to buy it in the damaged condition because the risk of loss under common law would have transferred to them at the moment there was an accepted offer. So we don't like that situation, and even though that's what the default is under the common law, our contract states that the risk of loss shall remain with the seller, which makes sense because the seller should already be insuring their own property, and it is kind of unusual for a buyer to go out and get insurance on a property they haven't closed on yet. Now, one thing to remember too, though, is this is another one of those paragraphs that if you'll note at the end of it, it says this paragraph shall survive the closing. So arguably the buyer could sell or go ahead and buy the property and then pursue the seller for the damage that the buyer suffered prior to the closing, or the property suffered prior to the closing. Now, one of the things I want to talk to you about is on line 249. That's paragraph 23 of the commission, or references the commission. And what it essentially is saying is that if for some reason this contract is unfulfilled and one of the parties is at fault, whether it be the buyer or the seller, they're going to be responsible for paying the commission of the agents. So the defaulting party who refuses to close or can't close, and for reasons other than ones that are covered by a contingency, is going to have to pay the commission of the agents. And what's important to remember about that is, let's imagine that you're a listing agent. You sell a property to purchaser A or buyer A, and buyer A just decides, I'm not going to buy it. Well, you've earned that commission. Now, you are then have to go sell it to somebody else, buyer B, which you do. Well, you've earned that commission too, because in essence, you've done your job twice. And what this ensures is that you get paid twice, meaning that you're going to get paid for that first commission, even though a closing never occurred, and you're going to get paid for that second commission because you did your job twice. It's the same thing as if saying, well, I mowed the lawn once and I got paid, and if I have to come back and mow it again, I should get paid for the second time as well. Now let's move on to paragraph 26. This is what's going to cover you if a dispute comes about. Now, we have mediation and binding arbitration. There is some real advantage to this as realtors. Mediation and binding arbitration was originally recommended by the E&O carrier in the state, primarily because it can keep the costs associated with litigation down. Another nice component of mediation and arbitration is even though it's not confidential, meaning either party can go out and talk about what happened, the one thing that you can't do is you can't open up the local newspaper and see in the court news section a dispute between X realtor and X party because it's not in the public record. So even though the parties can talk about it, you're not seeing it in the court records, you're not seeing it in the local newspaper. So there are some advantages to having it in binding arbitration as opposed to being litigated in the courts. Also, mediation is very often successful. I can say with our firm that when we mediate cases, I would say about whether we're the mediators, which we are, or we are the parties mediating, or the attorneys representing the parties mediating, you're really looking at about somewhere between a 65 to 75% success rate. And that's quite high. And that keeps down the number of claims that realtors have to deal with. And also it limits the costs that the participants, including the buyer and seller, are involved with. And the same when it gets to arbitration. Arbitration costs are normally significantly less than court costs. Arbitration is typically faster. And so all in all, mediation and arbitration are great for realtors. And I sometimes hear realtors say, well, I don't want to sign as the listing agent or the selling agent. I don't want to participate in that. And I think that is a huge mistake. It is to your advantage to do that. One, like I said, to keep your claims out of the public. Two, because it keeps your costs low. And three, it's beneficial to your clients. It's actually a better avenue to both settle disputes and to resolve disputes than going to court. So for all of the reasons above that I've cited, I think you're foolish not to agree to be part of the mediation and arbitration provision of this contract. Now, people have said, well, can a listing agent sign on behalf of the listing brokerage? Generally speaking, yes, because while you are the listing agent for the seller, you are also an agent, a parent agent on behalf of the broker. And what I mean by that is it is presumed that you have been given powers on behalf of the broker to sign for the brokerage, in essence, your willingness to participate in mediation and arbitration. One, by the fact that you're using this contract, and there's some legal doctrines that deal with apparent authority and what have you. And the same with the selling agent. The selling agent is deemed to have the authority on behalf of the buyer's brokerage to sign on behalf of the brokerage. So the question of do you need the broker signature or not? I personally don't believe you need the broker signature. I think an agent can sign on behalf of their broker and bind their broker. Now, you are only signing this for the limited purpose of the mediation and binding arbitration provision. You are not signing the contract for any other reason. And also, let me talk about this. If you chose not to sign, you could really cause a disruptive situation, because let's imagine that you want to recover your commission. That would mean that if a buyer didn't purchase when they were supposed to, the seller would be suing them through mediation and binding arbitration. And then you would be suing them in court in a separate action, and the seller would have to appear in both actions. You would in likelihood have to appear in both actions, and you could end up with inconsistent verdicts to where the seller could win their action, but you could lose yours, or vice versa. And cost would, in essence, in all likelihood, not completely double, but very close to double. So there are some real detriments to not signing the mediation and arbitration provision. Now, let's assume that you signed. Let's assume that your parties have not struck it out or done anything along those lines. You're going to see a couple of things that you should be aware of. First is that notice of demand for mediation must be made within 365 days after the party raising the claims knew or should have known of the existence of said claims. So what does that mean? The first thing that means is that if you're representing a party, let's say a buyer, And after the closing, they come to you, let's say 30 days after the closing, and they say, hey, the basement leaks, and I think the seller knew about it. Your first advice to them should be, you need to go talk to a lawyer. And that advice needs to come both from you personally, and that advice needs to be in an email. You need to email your client and make that recommendation. Now, if they choose to do so or choose not to do so, that's one thing, but you've done your job to making sure that you've recommended them and sent them to the right course. Because if you don't, and let's say through the course of these negotiations, these 365 days go by, you may, and you're trying to help them, the road to to you know where is paved with good intentions. You might have been working with them so nicely and so helpfully that their limitation period had passed and they can no longer bring a claim. So you want to be aware of right away. You tell them, go talk to a lawyer. Also, you want to be mindful of the fact that you are not a lawyer and that you can only give so much advice. And the more you give, the more liability you create on yourself. And I can tell you, in all likelihood, your broker's sitting there saying, don't do that. Have them call a lawyer. You cannot replace a lawyer. You should not replace a lawyer, and you're creating more liability toward you and potential damages against you if you try to do that. So right away, tell them to go to a lawyer. Tell them, hey, you got 365 days from the day you discovered the issue to get this mediation filed, the demand for mediation filed. Now, then they'll go to a mediation. If the mediation does not result in an agreement between the parties, then they have to go to arbitration. Now, again, there's an important date involved here, and that is that the arbitration hearing must begin within 365 days after the initial demand for mediation. So you essentially have 1 year from the date you know about a problem to demand mediation. And then once you demand mediation, you have 1 year to complete the mediation and the arbitration must begin. So while it seems like that's a long period of time, from the moment you send that demand for mediation, you really have 1 year to complete two scheduled hearings, or two scheduled matters. One being the mediation itself, which may take a few months, and then the arbitration, which may take several months to both organize, schedule, and perform discovery and related things within there. So your clients have a tight time frame. And it's important that you emphasize that to them. Now, there's some other components to this provision, but the key ones that you should remember is my recommendation that you sign as participants and be willing to participate both as agents in your brokerage to the mediation and arbitration provision. Also, that no matter what, when you're approached with a problem or a question by your clients, your first response is to advise them to talk to a lawyer. Now, the last part that I wanted to talk to you about, because it's come up a lot lately, is sellers' signatures and buyers' signatures. You really want to make sure that you have all of the proper signatures. And what I mean by that is that if the buyer is married and it's a husband and wife bind, that you have both of their signatures, but especially if the seller. Now, if the seller is married, you need to make sure they have all the signatures, even if the wife's name is not on the deed. I still think you need to make sure to go ahead and get them, because they do have, whether it be a dower or courtesy right in the property, you do need to make sure they have their signatures. You also need to make sure that if it's a corporation, that you have a corporate resolution that says they're authorized to sign. If it is a corporation, make sure that the person you're dealing with is actually empowered to sign, meaning they are a manager or a member. You really need to go through these steps to make sure you're doing the right thing, because I've had a lot of cases pop up lately where people have gotten the signature of one spouse and they didn't know about the other spouse, or a signature from a party they thought was a member or manager of the corporation and in fact did not hold that position. And anytime you have those situations, you really need to make sure that you clean them up by getting all the proper parties to sign. So that should be on your checklist early on, long before you get to the contract signature phase. But make sure you get those steps, because those are issues that are both problematic to the eventual closing, but may create liability on behalf of you and your brokerage for failure to getting that done correctly. Hopefully these tips have been helpful. Hopefully the video vignette series has been helpful, and that you can utilize all of this in your use of the Kentucky Realtors statewide contract.